Despite attorneys crying, "Beware of the 50-50 partnership," business owners often find themselves and insist on that exact relationship. In my experience, 50-50 partnerships, especially when a business is just starting, are a reality. A good attorney, however, should have the tools ready to help those eager business owners avoid the most common problems of a true 50-50 relationship: unresolvable deadlock. When owners insist on maintaining both the 50-50 voting power and distribution rights, there are a number of options available to owners to help avoid and/or resolve deadlock. First, owners and their attorneys should look into how the business will be run on the ground. Perhaps it is the intention of the owners that only one of them will be running the business on a day-to-day basis. If that's the case, the operating agreement should so state, and possibly should include a list of specific actions the day-to-day managing owner can take without the approval of the other owner. Setting this out on the front end will help define the expectations and understandings for both owners and keep the background partner out of the operating partner's hair. Certain major decisions could still require the approval of both owners. Second, the governing document should likely have simple and practical dispute resolution provisions. More times than I can count, owners have handed me previously drafted operating agreements that contain burdensome, overly formal, and expensive dispute resolution procedures, if their governing documents even contain a dispute resolution procedure. These provisions often state that disputes will be resolved by a mediation or an arbitration process. As legal professionals should now be aware, these procedures can be time-consuming, drawn out, and unnecessarily expensive. In small to medium-sized businesses with only 2 owners, even these types of dispute resolution procedures do not reflect the on-the-ground reality for how the owners would prefer to resolve disputes. For day-to-day decisions, I find it is almost always cheaper and more agreeable to delegate final decision-making authority in the event of a dispute to a known third party who would have expertise resolving that specific matter. For example, matters involving calculation of expenses or distributions might be better resolved by the business's CPA. Other disputes involving internal procedures and duties might be better resolved by the business's attorney. Valuations and appraisals should be conclusively resolved by one or more appraisers with expertise in the area. Only if there are certain decisions that the owners believe cannot be resolved adequately by a third party should the more formal dispute resolution procedures be available. Third, the governing documents should likely include restrictions on transfers, including a restriction preventing the owners from selling all or any portion of their ownership interest in the business to a third party. An owner likely doesn't intend to go into business with someone they have no say in selecting. On top of this, if the business does not have an operating agreement, the other owner is free to transfer a portion of his or her interest to another party, and, more importantly, under Georgia's default laws, each owner would have 1 vote, regardless of how much of the business each owner owns or how distributions have been divided. Under this scenario, an original owner could be outvoted on every single decision by the other 2, one of which the original owner did not choose to be a co-owner with. This is a type of deadlock resolution possibility that the 2 owners likely did not want or intend when they started their business. Fourth, the owner should consider deadlock buy-sell provisions. Whenever there is a possibility of a deadlock among business owners, their operating agreements should provide a mechanism that allows either of the owners to leave the business fairly in the event of a deadlock. One of the most effective mechanisms is a deadlock buy-sell provision, which allows one owner in the event of a deadlock to make an offer to the other owner to purchase that owner's interest in the business. The other owner would then have a period of time to either accept the offer and sell the interest or flip the offer and purchase the offering owner's interest. In theory, because the other owner can flip the offer, the original offer will be a reasonable and fair estimate of the value of the business. These provisions work better when the financial means of both owners is similar, although the provision can be revised to account for many different circumstances. These are just a few of the ways business partners can help avoid and fairly resolve deadlocks that may arise in the operation of their businesses. If you and your business partner are considering a 50-50 partnership or need assistance drafting an operating agreement or putting these protections in place, please feel free to reach out to me.